The goal today is to bring you up to date with the saga regarding patents for computer processes and internet business methods. As you recall, we left off with the 1998 State Street decision from the Federal Circuit Court of Appeals. In that case, the court concluded that business methods and computer-related inventions are patentable subject matter as long as they are applied in a useful, concrete, and tangible way. For all intents and purposes, this meant that anything in this field was patentable subject matter, and thus the only pertinent issues were whether the inventions were novel and non-obvious. This led to a few problems, especially with business methods, because the information about them was not well documented, at least in a publicly available sense. After all, businesses that are profitable due to certain ideas are not just going to willy-nilly tell everyone what has made them so successful. And for sure, they're not going to write those methods down and publish them or report them in the Wall Street Journal or anything like that. Especially at a time before State Street, when there was little prospect of protecting them with patents. The result was that there were lots of business methods out there being used somewhat secretly. Although they weren't well documented, people in the field kind of knew about them. In any event, after State Street, firms began to file patent applications for these business methods, and the examiners were just overwhelmed. Despite their best efforts, they couldn't find relevant information pertaining to the process, or recognize what many in the industry already understood. And so the PTO took a lot of heat for making mistakes in this arena and issuing patents when they may not have been warranted. On this slide here, I put a couple items under the heading, Light Touches on the Brakes. The first highlights one response by the PTO to help address concerns. The other refers to a court decision in notable litigation about Amazon's one-click shopping. As we shall see, it demonstrated that business method patents may not be quite the sword that detractors feared. So let's start with the Business Method Patent Initiative, which was an effort undertaken by the Patent Office to address what it recognized was a significant problem with patent quality in the field. One goal of the project was to give examiners more access to relevant sources of information by increasing the number and scope of databases they might use to find prior art. The PTO also made connections with experts in the industry to help examiners understand common practices more readily. In addition, the office added a new layer of scrutiny for business method applications. Due to the initiative, 2 supervisors would review an examiner's decision rather than just one, which is the norm with other technologies. These measures were somewhat effective since the percentage number of patents issued for business methods noticeably decreased after they were implemented. Now, before getting to the Amazon case, I want to mention the America Invents Act, which also added procedures to address patent quality concerns. These came somewhat later than the time frame for this slide, however. So, number 1, the new law added the possibility of opposition proceedings in the first 9 months after a patent is issued. This gives people in the industry a somewhat quick and relatively inexpensive way to challenge an examiner's decision, usually by introducing prior art that the examiner may have missed. Similarly, even after 9 months, the Act provides inter partes review procedures, which also can provide relief from examination errors. Okay, well, let's get back on track. I want to take this opportunity to look at Amazon's lawsuit against Barnes & Noble regarding its one-click business method, which the company patented in 1999. So the case is interesting in and of itself, since we are all pretty familiar with the one-click shopping process. And you probably never suspected it was actually patented. It also demonstrates the potential power of such a patent and how a well-financed company might be able to fight against it. So Amazon came up with the idea for one-click shopping in 1997 and filed its patent application in that same year. From today's perspective, you probably wonder how something so common and simple could ever be considered non-obvious. But that illustrates the problem of hindsight that the Federal Circuit raised in the cable tie case. You know, the PTO actually put an enormous amount of resources into its scrutiny of this application, from tapping private databases to employing additional search agents and including extra supervisors to the evaluation. Thus, the PTO gave this application as much attention as it possibly could, and based on its review, determined that the claims were novel and non-obvious. The patent was issued by the PTO in 1999. The case synopsis provides one of the claims. There were 26 in total, but you can get a good idea from this what we're talking about. It's also a good example of what claims for business methods look like and how they are drafted. Anyway, here are the basic details of Amazon's one-click method. The first time you buy something from Amazon, you have to give it certain information to complete the purchase, such as your name, shipping address, and credit card information. Amazon will store this information on its server and mark it with a code that it will use to identify your computer. Amazon will also put a file on your computer, it's called a cookie, that includes this code. Then, if you ever return to Amazon's website and want to purchase an item, you can choose the one-click option, which sends the code on the cookie to Amazon. Amazon then matches the code to the information on file and uses it to fulfill your current order. That's it. Easy peasy. Okay. By the time the PTO issued the patent in 1999, Barnes & Noble had already been doing the same thing with what it called the express lane option. So, just after the patent was granted, Amazon sued Barnes & Noble for patent infringement and asked the judge to issue a preliminary injunction. So, remember that with a preliminary injunction, the plaintiff, here Amazon, basically says, "Look, Judge, can't you see from a quick review that we are very likely to win after a full-blown trial, and that it would cause us irreparable harm if we have to wait the couple years it typically takes to complete the litigation. So please stop Barnes & Noble now. It's only fair that you do so." Barnes & Noble argued, "Don't do it! Can't you see that our express lane doesn't violate the parameters of the claim?" But the judge said, "At the moment, no. They look the same to me." Barnes & Noble then said, "But Judge, can't you see that Amazon's invention is not novel and non-obvious? Here, look at these examples of prior art that we found that the examiner never even looked at." But the judge, again, was not sympathetic, relying on several non-obviousness factors, such as commercial success and long-felt need. And so the trial judge issued the preliminary injunction, meaning that Barnes & Noble can't use the method until after there's a full trial, which the judge has indicated Barnes & Noble probably won't win anyway. So, ouch. So think about what the imposition of the preliminary injunction means to the parties in terms of bargaining positions. Barnes & Noble can't use the system until trial, meaning for a couple years, and has been given a strong signal that it won't be able to do so even after trial. Thus, if Barnes & Noble approaches Amazon wanting to negotiate a license to use the one-click method, Amazon can hold out for a pretty high sum since it bears little risk. On the other hand, had the judge not been convinced to impose the preliminary injunction, things would have changed markedly. For one, Barnes & Noble gets to continue using the method until trial. And the company has an indication that it might actually prevail on its claim that the patent is invalid. Knowing that, Amazon would likely be willing to settle for a much lower amount to get revenue for what Barnes & Noble has permission to keep doing, at least until trial. Also, if Amazon doesn't settle now, then it faces a more real prospect of losing the patent at trial, thus losing all its leverage going forward. Barnes & Noble appealed the ruling to the Federal Circuit, arguing that the trial judge was wrong under the circumstances to impose a preliminary injunction. The Federal Circuit agreed with the trial judge that Amazon was likely to be able to prove at trial that Barnes & Noble violated the patent claims with the operation of its express lane shopping feature. However, the Federal Circuit determined that the new prior art references introduced by Barnes & Noble raised some reasonable possibility that the relevant patent claims might be deemed invalid at full trial. The Federal Circuit evaluated the situation this way. It's like, let's see. There are these extra materials that the examiner never reviewed. And we have to look at them quickly and make a snap decision whether Amazon's invention is non-obvious in light of them. Golly, we're just not sure. Maybe yes, maybe no. It's very possible Amazon could lose. And given this, we can't really say it's likely that Amazon will win when the claims seem at least vulnerable to attack. So that was where the appeals court landed. If the claims are vulnerable in light of the new information, then the court should not impose the preliminary injunction. The case synopsis briefly describes some of the new sources of information that Barnes & Noble introduced, and why the Federal Circuit believed they raised sufficient questions about invalidity that the patent claims became vulnerable to cancellation. And so the court withdrew the preliminary injunction, meaning that Barnes & Noble got to continue using Express Lane until the full trial. So, as I mentioned, this means the bargaining power now swung more towards Barnes & Noble, and the parties quickly settled thereafter. We don't know for how much, but certainly the settlement cost Barnes & Noble less dearly than it otherwise would have. The Court of Appeals, in a sense, dulled Amazon's sword with its ruling. Here are a few wrap-up items about this case. For one, business method patents, which often have questionable validity in terms of potential prior art, lost some of their bite because they might not so readily result in preliminary injunctions. That was the light touch on the brakes, in my view. Also, keep in mind that the patent's vulnerability arose here because Barnes & Noble found credible prior art that had not been reviewed by the patent examiner. If the examiner had already reviewed those references and determined that the one-click claims were non-obvious in light of them, the court would have significantly deferred to the examiner's judgment, making the claims appear much less vulnerable. Finally, as you already know, the PTO can re-examine patent claims when a substantial new question about validity has been raised. So the agency did follow through after this case and re-examined Amazon's patent claims. And in the end, it did not approve the broadest claim, but did allow those with certain limitations, or as amended. All right, that's the Amazon case. For the remainder of this video, I'm going to give you a taste of the more recent landscape by exposing you to 3 relevant Supreme Court decisions, which, at the end of the day, I believe will leave you frustrated and even further confused. The first litigation, in Bilski, involved a business method claim that doesn't even involve a computer or machine for its implementation. However, the court's decision is still very relevant to internet and computer-related inventions because the court's potential acceptance of pure business method claims will matter when they are applied in the digital world, especially if the court's view is positive. Simplifying somewhat, the claim at issue in Bilski was a method for hedging financial risk in commodities. Among other things, the system provides a reasonable way for utilities to offer consumers fixed monthly energy bills based on their historical usage patterns and other considerations. In this way, the consumers can hedge the risks of facing a potentially harsh winter because they have already locked in their expenses. On the other side of the coin, the utility purchases coal from mining companies at a fixed price, which similarly hedges their risk that coal prices might fall. Bilski's business method essentially helps the utility determine the prices and relationships that make the hedges work effectively for all the parties involved. Okay, so that's a very general idea of the financial business method at issue here. The exact details don't really matter, except to emphasize that the claim is not limited to a computer or a machine for its implementation. The PTO examiner rejected the patent claims, finding that the business method simply related an abstract idea and solved mathematical equations. The Patent Trial and Appeal Board agreed, and so Bilski appealed to the Federal Circuit Court of Appeals. The Federal Circuit affirmed that Bilski's business method was not patentable subject matter, despite its ruling in State Street, which indicated that a process only had to produce a useful, concrete, and tangible result to be eligible. The Federal Circuit indicated that it had taken some heat for opening the doors so much in State Street, and that its standard had proven inadequate to address the issues. It thus wanted to dial things back a little bit more towards the concepts related in Diamond versus Deere, which involved a physical machine to transform raw rubber into a cured product. Thus, it came up with a revised test for patentable subject matter, requiring that the process either be tied to a machine or apparatus, or that transformed an article into a different state or thing. In this way, the court was looking for a way to distinguish abstract ideas, which are not patentable, from tangible implementations of ideas, which can be patented. So, Bilski's hedging method did not meet the test because it didn't involve a machine and didn't transform the physical state of anything. Rather, it only entailed an abstract financial concept and performed necessary mathematical calculations. Well, Bilski digs in his heels and appeals to the Supreme Court. And the Supreme Court determines that this issue is so important that it merits review. And the whole technology community watched closely, eagerly awaiting clarity in this increasingly important legal arena. But they were left somewhat disappointed. So, interestingly, the Supreme Court stated that the Federal Circuit went too far backward with the machine or transformation test, and that it was too limiting with the kinds of processes that should be accepted. The judges worried that emerging digital technologies, such as with artificial intelligence or advanced medical diagnostics, might not meet the Federal Circuit standard, despite warranting patent protection. That makes sense in my view, but the problem is that the court did not provide an analytical test or metric to replace the Federal Circuit approach. Rather, the Supreme Court simply ruled that Bilski's business method was not patentable subject matter because it was an abstract idea, without providing any guidance on what that means, or how to recognize when an idea is merely abstract. Beyond this, several of the judges indicated that business methods should be specifically excluded from patent protection, mainly because innovators don't need incentives from the patent system to develop them. However, the majority of the court agreed with the Federal Circuit that business methods can be patented, assuming, of course, that they are more than abstract ideas, whatever they are. All right. So next in line from the Supreme Court is Mayo versus Prometheus, which was especially important to those patenting in the medical field. Bear with me here because I'm not a medical doctor, but there are medications called thiopurine drugs that are helpful for treating autoimmune diseases, such as Crohn's disease. When a patient ingests these drugs, the body creates specific metabolites in the blood, which may be beneficial. Previous studies had shown that if the level of metabolites got too high, then the drug might be harmful. And if they were too low, then the dosage might be ineffective. However, the research had not uncovered the correlations with sufficient precision to be meaningfully useful for treatment. Prometheus Labs found these connections and applied for a patent for a process to optimize the efficacy of thiopurine drugs. The steps in the process were to administer the drug and then measure the metabolite. If the metabolite level was below 230, the drug dosage needs to be increased to be effective. And if it was above 400, it needs to be decreased to not be harmful. The PTO determined that this was patentable subject matter and was novel and non-obvious, and thus it granted the patent. The Mayo Clinic began using and selling diagnostic kits that effectively infringed the terms of the Prometheus patent, and Prometheus then sued. Mayo argued that the claims covered unpatentable subject matter, and the patents were thus invalid. The district court agreed, but the Federal Circuit did not. So up to the Supreme Court we went. The Supreme Court decided that the Mayo Clinic was correct. The claim does not entail patentable subject matter. I sort of get it. Prometheus did not invent the correlation between metabolites and the consequences. Rather, the company just discovered something that results from nature. And one can't get a patent on natural relationships. Sure, Prometheus added the steps of administering the drug and measuring the metabolites. But those are so conventional and necessary that if you granted the patent due to those additional elements, then Prometheus could effectively control all practical uses of the discovery. For this reason, the court invalidated the patent. Okay, That's fine, I guess. My gut feel is that this invention doesn't merit a patent either. I think few would disagree that the diagnostic relationship is a discovery and not an invention, and so cannot be patented. Where things get sticky is how you treat the process once the physical steps are included. The court states that they are so basic and conventional that they cannot elevate the discovery into a potentially patentable invention. Okay, but what does it mean for a step to be conventional? Does that mean that it's obvious? Because if so, then it begins to sound like the court is folding the non-obviousness requirement into the question of whether there is patentable subject matter. Perhaps this is just semantics. Maybe it's just legal mind fart. It doesn't really matter. Remember, though, that the PTO did originally find this invention to be patentable and thus non-obvious. So I'm not sure what to make of it. Are you unsatisfied? I don't blame you. What did we learn about identifying patentable processes from the Supreme Court? I can't definitively tell you. My take from Bilski and Prometheus was pretty much that you know it when you see it. The industry, of course, would like something a little more concrete, especially with inventions in the digital sphere. Unfortunately, the Supreme Court soon got an opportunity to add clarity with the third case in this series, which is Alice Corporation versus CLS Bank. Yes, next there was the Alice case, which finally gave us a business method, such as in Bilski, but that was also applied on a computer. All eyes were on the Supreme Court in 2014. After all, why would it decide to review this case unless it had something new to offer? In this case, Alice Corporation owns patents claiming a computerized method that uses an intermediary to reduce risks of loss when two parties settle financial obligations. The process involves several specific steps, such as establishing shadow records, which, frankly, I don't fully understand and will not endeavor to explain. But the key is that the patent claimed a financial management system that was specifically tied to a computer for its implementation. To make a long story short, Alice sued CLS for infringement, but the district court ruled the patent invalid for claiming merely an abstract idea. Alice appealed, and the Federal Circuit affirmed, but the judges were all over the map in their opinions and rationales. Alice then appealed to the Supreme Court, which decided to enter the fray. The court constructed a new two-part test for evaluating whether inventions encompass patentable subject matter. According to the court, the initial question is whether the invention is directed to an abstract idea. If the answer is no, then you are good to go. However, here, the justices believed that the use of an intermediary to reduce settlement risk was a fundamental economic practice long prevalent in our system of commerce. And for this reason, they concluded that the business method recited in the claim was an abstract idea. That's not the end of the story, though, because there is a step 2 that can save the day. Now we have to ask if the invention integrates the abstract idea into something more that involves an inventive application of the idea. So Alice's invention basically covers implementation of the method on a general purpose computer. And this just doesn't cut it for the court. Rather, something more is needed, like aspects that improve a technological process, or specific required steps that leave room for others to still use the basic idea. It's kind of like Prometheus, I guess. So I imagine that if Prometheus had claimed a very specific way to better measure the metabolites with a particular kind of instrument, then perhaps this implementation might have been patentable. Due to the limitations in the claims, doctors could still rely on the tried and true conventional ways to use the basic medical discovery. I think the court is basically saying the same thing in Alice. Everybody knows that you can implement an abstract idea on a general purpose computer, and everybody would love to do that. So you need to add some specific inventive elements that limit your exclusive rights, while leaving the basic idea open for others to use in traditional ways on a computer. Since Alice did not do that, its claims were invalid. What does all this mean? Well, let's see. The court did not state that computer software can't be patented or that business methods are not patentable. There was nothing definitive like that. It also didn't say that the mere application of a common process on a computer can by itself get you over the subject matter hurdle. So it didn't adopt any of the extreme positions that many legal observers had advocated. So where are we? I call it Alice in Chaos Land, because Alice only served to fuel further confusion rather than really clearing anything up. Here are just some of the problems. What is the line between a concrete and an abstract idea? The court said that Alice's business method was abstract because the concept was long understood and prevalent in commerce. But what if the method has not been around all that long, or involves a significant number of specific steps? Is it now something that is not abstract? And what are inventive applications of ideas? Are we rolling non-obviousness into this whole thing again? What kind of additional steps will be enough? Do they have to improve the functioning or efficiency of the computer operations? According to some of my colleagues, that may be the direction that some lower courts are taking. I honestly can't give you anything all that definitive to take home with you. Frankly, I think we're still in a world of I know it when I see it jurisprudence. So, what did Alice accomplish? Well, I did think it maybe nudged the patentability pendulum just a hair further back from State Street. But beyond that, I'm just not sure. What I do know is that patent lawyers now try to write claims with more limitations tied specifically to the operations of the computer, theoretically to leave the fundamental ideas available for others to use. But they still clamor for more definitive guidance, and so have begun to more aggressively approach Congress and the President to step up and directly define the role that patents should play with digital technologies. After all, this will be the backbone of future economic activity. And maybe it's become too much to ask courts to apply old laws from the era of the printing press to internet-based inventions and artificial intelligence. Maybe it's time for a new approach that makes sense in a more thoughtful way. All right. I hope you have a feel for some of the tension that has been raised in this area. It's really a conflict between those who oppose patents for computer programs and information technologies and those who fully support them. Beyond the conceptual debate about the subject matter, there are numerous issues that perhaps underlie the fierce disagreements. For instance, opponents of patents believe that patent incentives are not needed to stimulate investments in these kinds of technologies. They worry that the PTO examiners don't have the information at their fingertips, nor perhaps the expertise to make good decisions about novelty and non-obviousness. They believe that software engineers could be stymied by the sheer number of patented routines they may unwittingly use when designing software packages. They think that copyrights or trade secrets are more appropriate avenues of protection, and on and on. Supporters, of course, take the other side in all of these matters. Well, I think it's best to wrap this up now. So until next time, take care.